All right, our prosecutor is Mr. Cabrera. I'll get him on the phone and then we'll begin.
Hello?
Mr. Cabrera, Rob Crown here. How are you?
Good afternoon, Your Honor. I'm doing good.
All right, so we are in session on our 24th. We have Mr. Cabrera on the telephone for the state attorney's office. Hall is in the courtroom for the public defender's office. NJC, do we just have these two individuals here for now?
We have three in court.
All right, and do any of them need a translator?
Yes, we need Creole translators for deliberate.
Do we need a Spanish translator for anyone?
No.
Pardon me? You don't think there's anyone here who needs a Creole translator, even though he just
Creole, yes.
Creole, yeah.
Right.
He just said no Spanish.
Right.
All right, so we'll have to get a Creole translator on language line later, but for now I'll talk to the other folks. You all are here for your first appearance. You have the right to an attorney. If you have a private attorney, then please tell me that when we call your name. If you would like the public defender, then I will appoint one to represent you. When I call your name, I will advise you of the charge or charges pending against you, and I will determine whether there was probable cause for your arrest. If I issue a no contact order in your case, then you may not have any contact with the individuals listed, either directly or indirectly. That means you may not contact those individuals in any way, shape, or form, and no one else may contact them for you. If I issue a no weapons order in your case, then you must deliver all firearms to the sheriff as a condition of your release. You have the right to remain silent. Everything you say today will be recorded and may be used against you later. NJC, can you call their names for me, please?
Yes. Dennis. Yes.
Dennis McGid. All right, good afternoon, sir. Will you please raise your right hand to take an oath?
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you can put your hand down. Thank you. Sir, do you plan to hire a private lawyer or apply for a public defender?
Public defender.
All right, public defender is appointed. This is a battery domestic violence case. I've read the paperwork. I do find probable cause. Ms. Hall, comments on bond.
Yes, Your Honor, and his wife is here. But in the meantime, I believe that he has some mental health issues that he does have a report that they believe he has dementia and anxiety. We're going to be asking for ROR, Your Honor, if he has dementia, and also if he's gone, if you remember, like he was in custody or couldn't even follow a train of siege with withdrawal release earlier, from what I understand. Clearly he has some mental health issues, and I don't necessarily think it's weird. Doesn't know like that way we can help him through competency. And if you are not willing to do ROR, we're going to be asking to release on your order.
And how will you help him if he's released on his own recognizance? What will you do for him?
Get him competency. We're working on trying to find a place for him to live and applying for the legislative we'll also be asking for to not have a no contact, just a no violent contact.
Okay. So you would help him find alternative housing as necessary, and would you work with him to ensure that he receives his medication and takes his medication as prescribed by a medical professional?
We were going to be looking, he told me that he has a brother who lives here and another brother who lives in New York and he's going to out. We would also be asking to not to be originally appointed, but if you could just look at all this permanently so that way we can
So ordered.
As for medication, we can work, I mean, I don't know how we would do that, but we can make sure that he has family members take care of him.
All right. Mr. Cabrera, response from you, please.
Yes, Your Honor, and for future calls on the docket, if Ms. Hall could just speak up a little bit more, it's a little hard to hear some of what she's saying, but the state was just going to ask for at least the standard bond amount. The one concerning aspect of this was the victim stating this was the second time this has happened where he threw her to the ground. And also, no contact with the victim, relinquished firearms, and per the DV statute, I don't believe he has any priors.
All right. Ma'am, do you want to address the court, or are you just here to listen? If you want to do that, I need you to come up here and take an oath, please.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Okay, thank you, ma'am. What is your name, please? Miss Majid, how are you related, if at all, to Dennis Majid? Okay, and you're the alleged victim in this case? So I have a few issues I want to talk to you about. I'll ask you some questions, and then I'll also give you a chance to address the court if there's anything in addition that you want to tell me, okay? For this type of charge, I would oftentimes impose a no contact order as a condition of the defendant's release. That would preclude him from having any contact with you once he's released from jail. Do you understand that? Do you want me to do that? Stated differently, do you want to have contact with him? And I want that to happen, and I understand that he needs help, but you also need to be safe, and I'm equally concerned about that. And so tell me, are you concerned for your safety?
Well, I am, but he has nowhere to go.
What about I thought that I heard about a brother who already lives here and a second brother who may be moving down or coming down. Does he have any brothers?
Yes, two brothers. I'm sure he let everybody know he's a triplet, and they have the same condition he has.
Well, all three of
They
them?
live up north.
I'm concerned about allowing him back into your residence based on my review of the booking sheet and your own testimony that you too are concerned for your safety. Your safety is equally important. I'm sure you can understand that. And so if I release him, do you understand that the defense attorney who represents your husband has asked me to release your husband on his own recognizance? That means he would not be required to post any monetary bond amount. He would simply be released with a notice to appear at the next court date. Do you understand that? Do you have any comments on that?
Yes, sir. Possibilities. This is a condition. He's not criminal, except for when he was crazy, but now he's sent to a hospital. He's been sent home after they evaluate him and check his meds and everything, because he takes a lot of medication, and I don't believe it's working anymore.
Well, let me go to the attorneys and get their input on that question. Ms. Hall, do you have any comments on that? It sounds like a suggestion that perhaps he be released on his own recognizance, pending direct transport to a mental health facility for evaluation and treatment as a condition of his release. How do you feel about that?
I don't know how I feel about that, Your Honor, just because I feel like that would be, would it keep them just for an evaluation?
Well, for an evaluation and treatment, it sounds like he's got, I think you said, 2 different conditions that require medical treatment, dementia and bipolar. That would,
I think something's working against him.
because if I just release him on his own recognizance, but I don't allow him to go back to your residence, where will he go?
I don't know, there's no one down here.
To help him, to care for him. Mr. Cabrera, what's the state's position on that suggestion about a release to a medical health facility?
If we're able to do that, Your Honor, I'd feel more comfortable if we went that route, if that's how we went about that route. But if that's not possible, then yeah, Your Honor, the state would stay with the bond amount.
Ma'am, is there anything else you want to tell me?
No, I told you what I would like with the situation.
And what you would like, just to be clear, is that he go to a treatment facility rather than come home.
Yes.
Okay.
How long though? You know?
Well, that wouldn't be up to me. That would be up to the medical professionals. But after he would go through an evaluation and treatment as necessary. So that's something that's a medical issue, not a legal one. Hold on one second, sir. I want to listen to your attorney first. Ms. Hall. Can you be more specific? You're okay with what?
That he be sent to a mental health facility for evaluation.
Let me go to pretrial release. It was suggested earlier, I don't know if it was you individually or someone else that you work with who's attempted to communicate with him. Was that you?
Yes, it was me, Your Honor.
So my concern is if I release him to a mental health facility, in other words, he wouldn't be released until he has transportation coordinated, he has a bed space available somewhere, he has somewhere to go. That may take some time. Does the jail have any specific position on this particular case or what we do with him?
As far as that goes, I'm not sure. I was only involved because he did qualify for pretrial, but upon interviewing him, he disqualified him based on how the interview went. He qualified with the GPS, but as I was explaining, the rules of the program and the GPS monitor, he wasn't understanding. I told him he did some GPS, and fairly soon after that, he asked me like what the program was, why he would have to have a GPS, and was questioning why he was using custody.
Okay.
So we felt that he wouldn't be able to comply with the conditions of pretrial, and that he would end up with a warrant and possibly back in custody. So we didn't think that would be in his best interest.
Okay.
So for that reason, he didn't qualify. So that's as far as my extent of the conversation with him. I don't know what would happen like.
Well, let me ask you another question. That makes sense about pretrial release. I understand if he can't understand it, then he doesn't qualify.
Right.
Do you know whether right now the jail has the capability of administering his medication to him, all of the medication that he needs?
The healthcare staff is contracted, and I believe they have talked to him already, and they know mental health is talked to him. I believe that they work together to get him the prescribed medications.
Okay.
While he's in custody.
All right, Ms. Hall, anything else from you?
Yes, Your Honor, I was told by our competency attorney that we are not open to the direct transport to a mental health facility, and that we need to follow criteria 394.46. If you're not willing to do our Your Honor, we're just asking for a release bonds. We just don't, because if he's not able to be transported anytime soon to the Suffolk jail, there's no way to get out.
Okay.
We don't necessarily want that, and if for some reason they don't feel that he should be released from the mental health facility, we don't want them stuff here either.
Okay, well, the reason I have some concern about your request for an ROR is then he's released with no supervision and no assistance, because I can tell you, based on my review of the allegations and the testimony from Mrs. Majid, I am going to impose the no contact order, no trespass order. Not only am I concerned for her safety, but she is as well. And so my concern about releasing him on his own recognizance is he's got nowhere to go and no support network, no one to help him, and that's not good either. So, Mr. Cabrera, anything else from the state?
No, Your Honor, I'm following your line of thinking, and I agree with it.
Well, here's what I'll do. I am going to issue the no contact order and no trespass at the location of this incident, both of which are confidential. I've marked them as confidential on the order. I've also signed a no weapons order. Again, the public defender is appointed, and that's not a provisional or temporary appointment. That's a permanent appointment. And I'm going to set bond in this case at $2,000, or he can be released. If he doesn't post that bond, he can be released at any time if he has direct transport to a mental health facility where bed space is available for evaluation and treatment. Okay, so the defense attorney's concern, ma'am, is that if I simply said direct transport to a facility and then there's no facility with space available, then he would be sitting in jail indefinitely. So we don't want that either. So I've given him some options, okay? I've given him the direct transport to mental health facility as one option, the preferred option, right? I think we all want that. Or the $2,000 bond, okay? So that if it turns out that he just doesn't have anywhere to go, he does have the monetary bond as an option to get released, so he's not stuck in the jail indefinitely. Does that make sense to you?
Yes, but I don't understand the use of the direction, taking him directly here.
Right.
And that sounds good, but what is the problem with that? I don't choose that. Is there a negative in that?
If he does not choose that, or if you don't choose that route,
Yeah.
then the negative, I guess, if you see it as a negative, would just be his only remaining option would be to post a monetary bond.
I would like to take him to a hospital.
I would as well, and I hope that's what happens. But that's why I've given the both possibilities, because my hope is that that's what happens. We also need to refer this to mental health court here with Judge Martin. Yes, it has been already referred to Judge Martin?
I believe so.
Okay, thank you. Ms. Hall?
I just wanted to clarify, this resolution, would that be by the jail would be transferring him, or?
Doesn't matter to me. I'm not sure that the jail is willing or able to do that. It might be someone from the facility. I just don't want Mr. Majid to be responsible for getting himself there. I want someone to take him. So it doesn't matter to me who that is, but there's got to be a bed space available in advance, and he's got to go directly from the jail to that facility. All right, Mr. Cabrera, anything else from you?
Nothing further, Your Honor.
Ma'am, thank you very much for coming in, and good luck to you.
So you're going to take him to a place.
I'm not taking him anywhere. I just imposed that. I just gave him those options. So hopefully someone can coordinate that for him, a space available at a mental health facility, and take him directly to that facility. That's
Take him a week or whatever.
I don't know, because I can't speak to the space available at various facilities. I don't know that. I don't monitor their availability. So someone will have to do a little legwork to figure that out. And perhaps Ms. Hall can help you or direct you, point you in the right direction in that regard, okay? And also, let me say, Ms. Hall, as you know, I'm here for the rest of the week at 2 o'clock. If it turns into Thursday or Friday or even tomorrow and he's still there and you think of a better option, then bring him back. I'm happy to address him again on a 215 docket, okay?
Your Honor, just to clarify,
Yes.
once this treatment concludes, is he going to be released from custody of
If he is directly transported to a mental health facility, he undergoes an evaluation and any treatment that's necessary, and then he successfully completes that treatment, then he would be released from the facility out on the remaining conditions, which include the no contact, no trespass, no weapons orders until the case is resolved. Okay, thank you, ma'am. Good luck to you.
So where's he going now? Back to wherever he came from?
He's going to stay in the jail until he's either transported to a mental health facility or he posts a $2,000 bond. And I've told his lawyer that if she comes up with a better option, she can bring him back to me tomorrow, Thursday, or Friday, and I'm open to other suggestions. Does that make sense?
Yes.
Okay, thank you, ma'am. Good luck to you. Okay, and NJC, who else do you have there? All right, that's fine. Thank you, Mr. Majid. I've appointed a lawyer to represent you, and you can explain that to her.
Your Honor, I have James Sullivan next.
Mr. Sullivan, thank you. He's here on the charge of DUI over 1.5. Mr. Sullivan, have you applied for a public defender?
Yes, he has to.
All right, I'll appoint a public defender to represent you. Again, this is DUI over 1.5. I've read the paperwork, find probable cause. Ms. Hall, comments on bond. I'm told he's also eligible for pretrial release. And there's room? All right, thank you. Ms. Hall, are you requesting that in the alternative? Okay, Mr. Cabrera, comments on bond.
They would just be asking for at least a standard bond amount considering the high breath.
Okay, I did sign a no contact order with the witness in this case, along with the no trespass at the witness's address, no possession or consumption of alcohol. Those conditions apply regardless of which option he chooses, and that would be $1,000 bond or pretrial release. Thank you, sir.
Judge, next up I have Joseph Amato. He actually refused to attend. He's next on the docket.
So it's not a medical issue. He could have come if he wanted to.
Yes, sir. It's his decision.
All right, thank you. Oh, that's you, Mr. Verrano.
Yes.
Okay, Mr. Amato is charged with violation of a pretrial release condition, specifically no contact order, with Mr. Verrano.
Yes, sir. So it's a unique situation. I actually represent Mr. Amato on 20 CT 1928, 20 MM 1661. There was a no contact order entered at first appearance back on 10/13 as the booking sheet indicates. The name in the booking sheet is not what the order reflects. The first name is correct, the last name is different. That being said, there is some discrepancies within the booking sheet. The first name was correct, and obviously it's so it's I have a copy.
Okay, thank you.
And in the booking sheet indicates that Amato was speaking to Karina, which is referred to as the first name that was up.
Okay, so my first question to you is, your client has refused to participate. You want to waive his appearance. Okay. And so you're arguing PC based on these discrepancies.
That's correct.
And the first discrepancy is based on the first appearance court order that actually established the no contact order, and that is 20 MM 1661 and 20 CT 1928. And the name on the first appearance paperwork there says Joseph Peter Amato.
No, it's the no contact for the alleged victim.
Yeah, which is redacted.
But the one I gave you is not redacted.
Yeah, okay, I got it.
And that's in the booking sheet. It says Karina Serino.
Oh, I see.
So
Yeah.
it's a different name.
In the instant case, it's got two names put together,
Right.
and in the order, it just has the second half of that name.
Correct. And then he's speaking to, in the booking sheet, he's speaking to a Karina or a Tatiana. But in the booking sheet, it indicates that the order that I just provided you is that name, and that's not the name of the booking sheet. But
Okay, I understand.
he's not going to be eligible for bond. He's held without bond on violation of probation.
Okay.
So it's not an issue where he's going to be out. So
All right. Well, I understand the discrepancies. I'm going to give this copy back to you. Thank you. But I do find probable cause based on my review of that order and the booking sheet in the instant case. Do you have any other comments on bond?
no, Judge. Like I said, he's not going to be out on bond. He's held for a violation of probation as a result of the arrest.
Okay. Mr. Cabrera, comments on bond?
Yes, Your Honor. I believe I printed out in your courtroom and I also sent to your JA motion to revoke bond for 20 MM 1661 and 20 CT 1928. The state was going to ask for heightened bond of $5,000 due to the number of messages sent and his extensive criminal history. Since it's a DV case, per the DV statute, he has the battery that spawned this injunction, and I guess just reinforce the no contact order.
All right, and I did sign a new no contact order as well as a no weapons order. Bond is $5,000, and your motion to revoke bond is granted in 20 MM 1661 and 20 CT 1928. Thank you.
I have a 215.
All right, we'll be with you shortly on that. All right, NJC. Who else?
The only one we have left in the courtroom here, Your Honor, is the one that requires the pre-all interpreter.
All right. I know it's difficult to switch courtrooms over there. Let me see if I can get language line on the phone real quickly here for this person, okay? Who is that? Marnell Bellegarde.
Welcome to Language Line Solutions. Please enter your 6-digit client ID. For Spanish, press 1. Please speak the name of the desired language.
Creole.
I understood. Creole. If this is correct, say yes or press 1. If this is incorrect, say no or press 2. Please speak the name of the desired language.
Creole.
I understood. Creole. If this is correct, please speak the name of the desired language.
Haitian Creole.
I understood. Haitian Creole. If this is correct, say yes or press 1. Please enter your access code followed by the pound sign. Please hold for an interpreter. Please continue to hold for the next available interpreter.
Miss Hall, do you know if you applied for your office? NJC, did Mr. Bellegarde apply for the PD to your knowledge?
No, he did not.
Okay,
Please
thank you.
continue to hold for the next available interpreter. Please continue to hold for the next.
Okay, so Ms. Hall, my inclination, I know that he hasn't applied, would be to appoint your office contingent upon an application and his qualification. How do you feel about that? All right, so this is Marnell Bellegarde, 21 MM62. So the public defender is appointed with that understanding. Ms. Hall, obviously I was unable to get a hold of a Creole translator. We do not have one, just for the record, available in the courthouse today. What would you like to do? I'm happy to do that. I'm wondering, is he held on no bond is set by judge? Yeah. So right now there's no bond set. Let me ask you this, Mr. Cabrera. So Ms. Hall now represents Mr. Bellegarde. Have you read the booking sheet?
I did, Your Honor.
It's an interesting situation. The alleged victim told law enforcement upon their arrival that she hit him first, that she walked over to his apartment. He answered the door. They had a disagreement and she hit him. That's what she said to the law enforcement officers, and that's what he said to the law enforcement officers. And then after she hit him, he grabbed her shirt and hit her back. So the facts appear to be fairly undisputed.
Yes.
So how do you feel about the probable cause determination with those facts, Mr. Cabrera?
I anticipated that might be an issue, Your Honor. The state would argue that while there was an argument that the first slap could be considered self-defense, The second slap, we would argue, would not be. Also, there wasn't an equal amount of force displayed, as no mark was found on the defendant, whereas the victim is described as having a ripped shirt, a swollen right cheek, and a red eye.
Ms. Hall, do you have any comments on that? And this is just all by way of a conversation. I'm concerned about holding him another 24 hours with no bond set, considering the question I have in my mind about PC. So we still have the option available that you suggested, which is bringing him back tomorrow, but I thought we should address this first.
There's something in here that says that the threat that he said to her, which was just verbal, actually scared her enough to defend herself, so I don't see how it could be argued as self-defense, and she was, as she said, the primary aggressor.
Well, law enforcement found that she was the primary that he was the primary aggressor. It's just an interesting situation. So self-defense obviously is a defense at trial. My question is, and whether there's a future motion, if sometimes we have cases where there may be a motion to suppress or a defense that may be available at trial, that typically does not preclude the court from a finding of PC at 24s. My question is really a legal one in this case. If the fact pattern does qualify as self-defense, does that mean it's not a battery? Or is it just a defense to the battery at trial? I mean, it's an interesting legal question. Does it mean that his actions do not constitute a battery? Which would go to my finding of PC, right? Does that make sense? Of course, we don't have a translator. And so there's not a whole lot we can do. I wanted to share with both of you my concerns about that and my concern about holding him with no bond for another 24 hours because we don't have a translator available for him. So, Ms. Hall, do you have any final thoughts or suggestions on how to proceed?
He does qualify for pre-trial release, Your Honor. We would ask for that, but if the release are simply not necessarily
Your Honor, I called language line this morning. I don't know if I have a good number for them, but I got a hold of them as soon as I called. I think got transferred to the number. I'm not sure if I'm the one. I never had access, but it's something I've been here.
Well, that's okay, but when you did that, did you explain the pretrial release option to him?
I did, Your Honor. He said he would call a friend to have a friend bond him out.
Bond him out monetary or through the pretrial release?
Bond him out monetary instead of pretrial.
So-
Not want to do pretrial.
Oh, he's not interested in pretrial.
Right.
Okay.
I guess in that case, I would ask that we try to get it. How would you like to look at it?
Mr. Cabrera, how about you?
Your Honor, I couldn't hear what she said last. Are we proceeding forward?
She has, Ms. Hall said that she would be more comfortable having a translator here so that he can participate in our conversation and at least listen to it.
Yeah, I understand that, Your Honor, and I think I would agree on that.
Okay, so here's what we're going to do. We're going to return this case tomorrow. Again, public defender is conditionally appointed. We'll return him to court tomorrow, but I'm not going to hold him no bond. Right now, he has no way of bonding out. And so I'm going to set a bond of $1,000 or pretrial release, reserving the right to adjust that tomorrow, Ms. Hall, when we can have a full hearing on the matter. That's just based on my preliminary review of the file. And again, the intent is that he's not sitting in jail for an extra 24 hours on a no bond status, considering my concerns about PC. And that'll give you two a chance to do some research too, if you want to. So I'm going to sign this pretrial release order, even though he said originally he's not interested in that. So it's $1,000 or pretrial release to be addressed again tomorrow in court at 24. So this is a return to court tomorrow.
Your Honor, are you going to sign a no contact order?
Yes, thank you. I did sign a no contact order with the alleged victim along with the no trespass order for her apartment and the no weapons order. So he would have to comply with all of those conditions in order to post that $2,000 bond or to enter into pretrial release.
When I go to tell them the words later, I'll call them and I'll try to let them know what happened today.
Very good, thank you.
So the purpose of tomorrow, Your Honor, would be to establish whether there's PC or not. So today he has the bond 1,000 or PTR. If he does choose to exercise that option today, as the condition of him doing so, he'd need to appear tomorrow so that he's present for the probable cause determination.
Well, he doesn't need to appear tomorrow. If he bonds out or enters pretrial release, he doesn't need to come back. If he does come back, then we'll make, hopefully we have a translator and we can fully discuss the issue of probable cause. And so the $2,000 and the pretrial release may change if I find no PC. Then it would change to an ROR. That's why I say I reserve the right to change those orders tomorrow.
Okay.
So yes, we're coming back tomorrow to address probable cause, which may indirectly affect the bond, right? His release status. Make sense?
It does, Your Honor.
Okay, thank you. NJC, anyone else in this room?
Your Honor, not for the 24 docket.
I know we have a 215 docket. I still have 3 people on my first appearance docket. Okay. Why do I have Jeremiah Lassiter? Is that someone who's bonded, maybe?
No, Your Honor. He should be in custody.
I'm not showing him on the computer here, but I have the paperwork. All right, NJC, how many folks do you have there? Is it just the one? All right. Can you have all 5 of them stand up, raise their right hand to take an oath?
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Jura o afirma que el testimonio que va a dar será la verdad, toda la verdad y nada más que la verdad. Yes.
All right, thank you. So NJC, I take it if you've got 5 people there, it's a mix of 24s and the 215 plea docket, right? Okay, very good, thank you. So for those of you who are here for 24s, do we need a translator? For 24s or for the plea? 24s. All right, when we call your name, we will advise you of the charge or charges pending against you.
Cuando llamemos su nombre, se le va a advertir el cargo o los cargos en su contra.
I will determine whether there was probable cause for your arrest.
Yo voy a determinar si existió motivo suficiente para su arresto.
And address the conditions of your pretrial release.
Y le voy a indicar cuáles son las condiciones para que pueda salir.
If I issue a no contact order in your case,
Si le impongo una orden de no contacto en su caso,
then you may not have any contact with the alleged victim directly or indirectly.
entonces no va a poder tener ningún tipo de contacto con la presunta víctima, ni directo ni indirectamente.
That means you may not contact the person listed in any way, shape, or form.
Eso quiere decir que usted no va a poder ponerse en contacto con esa persona de ningún modo.
And no one else may contact the person listed for you.
Y nadie más va a poder contactar a esa persona a nombre de usted.
If I issue a no weapons order in your case,
Si le impongo una orden de no posesión de armas en su caso,
then you must deliver all firearms to the sheriff as a condition of your release.
entonces como condición de su salida deberá llevar todas sus armas al cuartel de la policía.
You have the right to remain silent.
Tiene el derecho de permanecer callado.
Everything you say today will be recorded
Cualquier cosa que diga en el día de hoy va a ser grabada
and may be used against you later.
y podría ser usada en su contra más adelante.
You have the right to a lawyer.
Tiene el derecho de ser representado por un abogado.
If you have a private attorney, then please tell me that.
Si tiene abogado privado, por favor, infórmemelo.
If you'd like the public defender, then I will appoint one to represent you.
Si desea el defensor de oficio, me lo indica y le designaremos uno.
Sir, what is your name?
Señor, ¿cuál es su nombre? ¿Cómo?
Daniel Duran?
Daniel Durán.
Do you need a translator? All right, Daniel Duran is here on our 24's docket, charged with driving on a suspended license. Have you applied for a public defender? And I'm sorry, Ms. Hall, did you need to make some comments to them before we proceed? All right, Mr. Duran, you said yes to the public defender? All right, public defender is appointed. I've read the paperwork. I do find probable cause. Ms. Hall, comments on bond? State?
Standard bond amount, Your Honor.
Bond is 500. Thank you, sir. Oh. 500 or pretrial release in the alternative. Thank you, sir. And there's room? Thank you. All right. Sir, what is your name? Jeremiah Lassiter. Here is a fugitive from justice out of Pinellas County on a driving on a suspended license charge. I've read the paperwork. I do find probable cause, and bond is $1,000. Thank you, Mr. Lassiter. Madam Clerk, you good? All right. Sir, what is your name, please? Raymond Mershon is charged with violation of an injunction for protection against domestic violence. Have you applied for a public defender? Oh, no, Mrs. Human.
I'm covering for Mr. McLean today, Your Honor.
All right, so we have Mrs. Human here covering for private counsel on Raymond Mershon.
And we do not have a probable cause argument, Mr. Honor, with yes.
Okay.
I'm not sure if there was actually a bond already set on it.
Well, not to my knowledge.
We would ask for $1,000 bond. It's just a personal misdemeanor, and the allegation is one phone call.
All right, Mr. Cabrera, response.
Your Honor, I have no issue with the standard bond amount for this. However, the state does have a motion to revoke bond on 20 CT 2332 and has order printed out in the courtroom.
All right, go ahead with your motion.
Your Honor, we'd be asking to revoke bond on that since he did previously post bond for that, and he has new law offense being this one.
All right, Mr. Mershon, I've read the paperwork. I do find probable cause. I've signed a no contact order for the alleged victim and a no trespass order for this particular address, both of which are listed in the paperwork but marked as confidential. I've also signed a no weapons order, which I just explained to you. Bond is $5,000, and the state's motion is granted in 20 CT 2332. Thank you, sir, and thank you, Mrs. Human. All right, do we say it again? $5,000. Yes, Miss Hall. Oh, sorry.
I have that case as a personal citation.
All right, well, so he's not in custody. Mr. Cabrera, they're telling me that.
Yes, Your Honor.
Did you hear that? That he's out on a citation on that CT case?
I thought I checked that he had a bond set for that case. Let me.
I think the state may be correct.
All right, well, I've issued my order, and if there is an error there, you can file a motion, Mrs. Human, or the council can.
I see that. Yeah, I do that for 20 CT 2322. I'm looking at the first appearance order, and there was one was set at 1,500 for both counts for the DUIs.
Order stands. Thank you. Jose Luis Godinez, resisting arrest without violence. Sir, do you need a translator?
Señor, necesita intérprete. Yes.
What is your name?
¿Cómo se llama? José Armando Ruiz Godínez.
All right, I find that he does qualify for a Spanish translator.
Califica para un intérprete.
Did you apply for a public defender?
Solicitó defensor de oficio. Yes.
Public defender is appointed.
Se le designa defensor de oficio.
I've read the paperwork and find probable cause.
Leí sus papeles y encuentro motivo fundado para su arresto.
Ms. Hall, comments on bond. State?
Fee schedule bond of $2,000, Your Honor.
Bond is $2,000
La fianza es de $2,000.
and no possession or consumption of alcohol.
No puede poseer ni consumir bebidas alcohólicas.
Thank you, sir.
Gracias.
And that completes our 2 o'clock docket. Madam Clerk, when you're ready to switch to 2:15, you're good? What's the question?
If he can get out. He has an ISO.
Oh, well, I think there's an immigration detainer against you, sir.
Señor, pienso que hay una detención de parte del Departamento de Inmigración en su contra.
Which means you will not be able to get out.
Eso quiere decir que no va a poder salir bajo fianza. And then how will I be able to get out?
Well, I did appoint a lawyer to represent you.
Le designé un abogado para que lo represente.
So you can talk to her about that.
Puede hablar con ella de eso.
Thank you, sir.
Gracias. Puede hablar con su abogado que se le designó.
All right, NJC, you've got one person there on my plea docket. All right, sir, what is your name? Oh, this is Mr. Fuller. 2 cases with Ms. Hall. Madam Clerk, you said you're ready to proceed?
I'm ready.
Mr. Cabrera, are you ready to proceed on the 2:15 docket?
Yes, Your Honor.
All right, Mr. Fuller has 2 cases with us, 18MM 2376, 19 CT 717. Ms. Hall, do you need any time to speak with him?
Yeah, I just want to.
And do you want to do that off the record?
Yes, please.
Okay. So we're going to be in a brief recess here, Mr. Cabrera, to give Ms. Hall a chance to speak with her client. So I'm going to take us off the record, and I'll put the YouTube stream on mute. Okay, we're back on the record. Ms. Hall, what would you like to do? We've got Mr. Fuller here. I can. All right, well, let's ask Mr. Cabrera. So we've got 2 cases with Mr. Fuller. Each is a violation of probation. What is the offer, Mr. Cabrera?
The offer, Your Honor, is to revoke 75 days jail, credit for time served, court costs and costs of prosecution. Also to be noted, there's a 6 month driver's license suspension due to the adjudication of guilt.
Is that your understanding? Mr. Hendrick, do you agree?
I just wanted to ask if they're aware of the
That's for the VOPs, by the way, Your Honor.
charge last week, and they issued a Whitman Act on Friday, I believe. I didn't try to communicate with the state this morning. I'm not sure if Cabrera received any emails from this.
Mr. Cabrera, did you hear Mr. Hendricks? He wanted to make sure you're aware of an amended affidavit of violation that's coming down based on a new arrest.
Yes, Your Honor, and then I forwarded that to Ms. Karimi, who's handling the case, and that was the offer she crafted after considering all the evidence, or all the context.
Okay.
Yeah, very well. Can we move this to another day? You know, I want to talk before he takes it. He has an admission to that.
Well, do you know whether he would be getting out if he admitted it today? I mean, I'm happy to bring him back tomorrow. I just don't want to keep him in jail longer than necessary. Mr. Fuller, let me ask you a question. The offer in both of these VOPs is 75 days in jail with credit for time served. Your attorney wants to roll this to tomorrow or Thursday or Friday to talk to you because apparently this involves a new charge, and she doesn't want you to do anything that might incriminate you yourself on the new charge. If we roll this till later in the week, would you still be in jail anyway, or is it your understanding that you would be getting out today? Well, she wants. Well, it's 75 days, and that's what the state just said. It's based on the amended affidavit with the new charge. So I'm trying to figure out whether you will still be in custody later this week. Ms. Hall is saying that even if we took your admission today, you're not going to be released. So that's what I wanted to know, because then there's no prejudice to you if we come back tomorrow. Is that what you want?
Can we set it, I can only send Bill to this 24 hours in advance. So
Okay.
Can we next Tuesday?
We can do Thursday or Friday.
Yeah, can we do Thursday and I'll set it for tomorrow so I can talk to him about it.
You're sure he'd still be in jail anyway? Okay. Mr. Cabrera, the request from Ms. Hall is to continue both cases to Thursday afternoon at 2:15. Any objection?
No objection, Your Honor.
All right, Mr. Fuller, we're going to give you some time to speak with your attorney, and I'll see you Thursday afternoon, 2:15. Thank you, sir.
I'm gonna set a jail visit with you right now, because with this, the fact that they amended your affidavit changes things. If you take it today, you'll be basically admitting that you did the other crime, so I wanna talk to you about that before we do anything, okay?
All right, and you'll have some time to do that. So we'll see Mr. Fuller back on Thursday afternoon, and I think, Stephen, we're switching courtrooms now.
I'm setting it for tomorrow. I can only set them 24 hours in advance.
All right, thank you. We're going to NJC 1. Is that, all right. Mr. Verderamo, I'm going to take you as soon as we end up in the right courtroom with your client. All right, good. He needs that every once in a while. Yeah. And Mr. Valiz as well. As soon as I get to your client, I'm happy to take your case, okay? We're just jumping around different rooms here. Okay, NJC, how many folks do you have with you over there?
We have two, Your Honor.
Can you tell me their names?
Mary and Curry and Toddy.
All right, so one is with Mr. Verderamo. Will both of you please stand up and raise your right hand to take an oath?
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
All right, thank you. So Mr. Curry, come forward. Mr. Toddy, you can have a seat. We'll call you next. This is James Curry, 20MM 1443 with Mr. Verderamo.
You can stay on the record. I just need.
Oh, sure, go ahead.
Mr. Curry, this is the case that got continued last time because they couldn't bring you to court because you were in custody. It's an adjudication, time served, time away, right? No contest. This is the same case we talked about. Okay? Sounds good. All right. Thank you. Thanks, Judge.
All right. Did you say the offers and adjudication, time served, and court cost prosecution?
Yes. And he's in custody and he's not going to be released to yes, for some time.
All right.
Your Honor, let me double check, but I believe there's a $250 fine according to the notes.
Well, what I'm more interested in is a no contact order with the alleged victim and restitution, if any. So I need an update.
As far as restitution, there is a note in the file saying the victim got all the restitution already from the defendant.
Okay. How about a no contact? Was that an intentional omission on your part or an oversight?
I
can tell you,
considering the nature of this, I think it would be. There's no. I would ask for a no contact order just as a court order to stand. I know there's no probation, but.
Mr. Verderamo?
Well, it's my understanding we've taken depositions. This is also attached to a felony case of felony arrest and deposition based on Appearence reputation from Carmen Reyes. She doesn't want to have contact with Mr. Curry, so I believe it was intentionally omitted. So
she told you that in a depo?
Yes, she does not want to prosecute. She feel a lack of prosecution is not one for the case in deposition. She basically not cooperated with the state. What I can do is I'll reset it. I'll reach out. The no contact order was not one of the contemplated.
Well, we may be able to get there today.
Okay.
Let me ask him another question though. So, Mr. Cabrera, Mr. Verderamo has just represented to the court that the alleged victim has said under oath in a deposition that she does not want to prosecute, and she does not want a no contact order. And if that's your understanding, then I would be willing to proceed without that order. Do you have any information on that?
Yes, Your Honor. I have a note saying that she does, as far as the not wanting to prosecute, that is there. I don't see a note regarding the no contact, not wanting a no contact order, so I do not know either way on that.
I would be willing to accept Mr. Verderramo's representation that she said that at a depot, especially I think that's corroborated by the fact that she's filed a drop charge request. So the only remaining question is, you have a $250 fine, Mr. Verderramo does not.
We're fine with it. That's not an issue.
Did you confirm that, Mr. Cabrera?
Could you, I did not hear that.
It's not a problem, Judge. Well, James, there's going to be a $250 fine attached to the case. Are you okay with that?
Yes, sir.
Okay, sir, tell me your name, please.
James.
All right, Mr. Curry, the offer that's been made to you is an adjudication of guilt, $250 fine, court cost of prosecution, and time served. Do you understand that offer?
Yes, sir.
Any questions about it?
No, sir.
Do you want to accept the offer? Are you pleading guilty or no contest?
No contest.
Did you read and sign a plea form?
Yes.
Do you understand everything that's explained on the plea form?
Yes, sir.
Do you understand that by entering your plea today, you are waiving all of those?
Yes, sir.
Do you understand that your plea will be used against you in a deportation proceeding if you are not a United States citizen?
Yes, sir.
Are you under the influence of drugs, alcohol, or medication?
No, sir.
Mr. Verderramo, will you stipulate to venue and the factual basis contained in the discovery material? All right, Mr. Curry, I'll accept your plea. Find it freely, voluntarily, knowingly entered upon a factual basis and in your best interest. Adjudication, $250 plus cost, time served, 90 days to pay. All right, thank you, Mr. Curry. Thank you, Mr. Verderramo. You as well. Accept. Bless you. Okay, now we have Mr. Toddy, 20 mm 1464 with Miss Hall. How about no trespass at Home Depot? That's where this originally occurred. I would require that as an additional condition. I'll talk to him about that in a minute. Count two.
Count two, breach of the peace, and adjudication of guilt, 30 days in jail, credit for time served.
So it's the same offer, both counts. Mr. Cabrera, do you, sorry, go ahead.
And for the record, you might get a
Okay, thank you. Mr. Cabrera, do you agree with the terms?
That's correct, Your Honor.
Sir, what is your name, please? Mr. Toddy, you're here on two charges, trespass and breach of peace. The offer that's been made to you is the same offer in both counts. That's an adjudication of guilt, court costs, costs of prosecution, public defender costs, and 30 days in jail with credit for all time served. You understand that?
Yes, sir.
I would be adding one additional requirement, and that is no trespass at Home Depot, which is located at 1651 Airport Road South in Naples, which means you cannot return to that location. So I would add that as a condition to both counts. Do you understand that?
Yes, sir.
Do you have any questions about that addition? Do you still want to accept the offer? Are you pleading guilty or no contest?
No contest.
Did you read and sign a plea form?
Yes.
Do you understand everything that's explained on the plea form?
Yes, sir.
Do you understand that by entering your plea today, you are waiving all of those rights?
Yes, sir.
Do you understand that your plea will be used against you in a deportation proceeding if you are not a United States citizen?
Yes, sir.
Are you under the influence of drugs, alcohol, or medication? Ms. Hall, will you stipulate to venue in the factual basis contained in the discovery material? All right, sir, I will accept your plea. Find it freely, voluntarily, knowingly uttered upon a factual basis and in your best interest. Adjudication on both counts, judgment and sentence as I previously stated. Thank you, Mr. Toddy. Good luck to you, sir.
Yes, you do not have to serve any more time.
All right, you too. Thanks.
Thank you.
All right, switching to JC. Thank you, NJC.
Thank you.
Accept. Is the balance of the docket in IJC? All right, thank you. Oh yeah. 1, 2, 3, 6 cases. No, we should have 3. We'll see. Hello, IJC. Can you hear me? All right. How many folks do you have with you over there today?
I have 2.
Can you tell me their names? Oh.
Hey, but
Can-
IGC, could you hear that question?
Can you still hear me?
Yeah, we can.
I'm wondering.
Yes, I have the thing on you.
Okay.
It's Nelson Lopez, and Christopher Ott.
Okay, thank you. So let's, I would like both of you please to stand up and raise your right hand to take an oath.
Póngase de pie para tomar un juramento.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Jura o afirma que el testimonio que va a dar será la verdad, toda la verdad y nada más que la verdad.
Yes.
Yes.
All right, thank you. Let's start with Nelson Lopez. And he is here on 2 cases with Mr. Valise, and that's 19 CT 2761 and 20 CT 201. Is this the one we need a translator?
Yes, sir.
Yes, sir.
Okay.
Señor López, usted está aquí con 2 casos diferentes. El 19 CT 2761 y el 20 CT 201.
Mr. Valise.
Thank you, Your Honor.
Yes, sir.
We have reached a global resolution stage with 2 charges.
Hemos alcanzado una resolución global que incluye los 2 casos con el Estado.
Your Honor, for the first charge
Por el primer cargo,
is 20 CT 201.
20 CT 201.
The resolution in that case is 15 days jail for effort time served.
La resolución en ese caso son 15 días de cárcel, tiempo cumplido,
Court costs
costas procesales,
and cost of prosecution.
honorarios de fiscalía
And with regard to 19 CT 2761,
y con relación al 19 CT 2761.
the resolution in that case is revoke and re-sentence to 60 days jail with effort time served.
La resolución es revocar la probatoria a 60 días de cárcel y
With credit for time served,
crédito por el tiempo cumplido
with conditions outstanding.
y con las condiciones que continúan vigentes.
All right, thank you. Mr. Cabrera, do you agree with the terms?
That is correct, Your Honor.
Mr. Hendricks?
Yes, sir.
All right, thank you. Sir, what is your name, please?
Señor, ¿cuál es su nombre, por favor? Nelson Marroquín López López.
All right, and the first case, Mr. Valise, that you referenced is a driving on a suspended license charge, right?
That's correct.
And that's a new pending violation, not a VOP.
Yes, sir.
All right, sir, in case number 20 CT 201, you're charged with driving on a suspended license.
Señor, en el caso 20 CT 201, el cargo en su contra es de haber conducido con la licencia suspendida.
The offer in that case is an adjudication of guilt,
La oferta en ese caso es que su culpabilidad va a constar,
court costs and costs of prosecution,
costas procesales, honorarios de fiscalía,
15 days in jail with credit for all time served.
15 días de cárcel con crédito por el tiempo cumplido.
Do you understand that?
¿Entendió esa oferta? Que se escuche. Yes.
In case number 19 CT 2761,
En el caso 19-27-61,
you're here on a violation of probation.
usted está aquí por haber violado la probatoria.
The offer is an adjudication of guilt.
La oferta es que su culpabilidad va a constar
Court cost prosecution,
costas procesales, honorarios de fiscalía,
60 days in jail,
60 días de cárcel,
with credit for all time served.
crédito por todo el tiempo cumplido.
Your probation will be revoked
Su probatoria va a ser revocada
with conditions outstanding.
con las condiciones que tiene vigentes.
Do you understand all of that?
¿Entendió todo eso? Yes.
Do you have any questions about either case?
¿Tiene alguna pregunta relacionada con cualquiera de los dos casos? No.
Do you want to accept the offer in both cases?
¿Quiere aceptar las ofertas en ambos casos? Yes.
All right, in case number 20 CT 201,
En el caso 20-CT-201,
that's the new charge of driving on a suspended
este
license.
es el nuevo cargo por haber conducido con la licencia suspendida.
Are you pleading guilty or no
¿Se
contest?
declara culpable o no disputo? No contest.
In case number 19 CT 2761,
En el caso 19-CT-27-61,
that's the VOP.
esa es la violación a la probatoria.
Do you admit that you were placed on probation
Admite que usted fue puesto en probatoria
in Collier County for DUI
en el condado de Collier por haber conducido bajo la influencia
on March 6th, 2020?
el día 6 de marzo del 2020.
And do you admit, do you admit that?
¿Admite eso? Yes.
And do you admit that you violated conditions 1, 2, 7, and 8 of your probation?
Y admite que violó las condiciones 1, 2, 7 y 8 de su probatoria. Yes.
Have you read a plea form and a violation of probation admission form?
Leyó un formulario de declaratoria y un formulario por haber violado la probatoria. Un formulario de declaración de culpabilidad y uno por haber violado la probatoria. Yes.
Do you understand everything that's explained on those forms?
¿Entendió todo lo que estaba explicado en esos formularios? Yes.
Do you understand that by entering your plea and your admission,
Comprende que al hacer esta declaratoria y admitir su violación,
you are waiving all of those rights?
está renunciando a todos esos derechos. En los papeles. Yes.
Do you understand that your plea and your admission
Comprende su admisión y su declaratoria
will be used against you in a deportation proceeding
será usada en su contra en una audiencia de deportación
if you are not a United States citizen?
si no es ciudadano estadounidense. ¿Entendió eso? Yes.
Are you under the influence of drugs, alcohol, or medication?
¿Está bajo la influencia de drogas, alcohol o medicamentos? No.
Driving on a suspended license is an enhanceable crime.
Conducir bajo la influencia es un delito que empeora.
If you commit that crime again,
Si vuelve a cometer un delito similar,
then you may face higher fines,
entonces tendría que pagar multas más altas,
more jail time,
más tiempo de cárcel
and possibly a felony charge.
y posiblemente una acusación de felonía.
Do you understand that?
¿Entendió eso? Yes.
And your plea to the driving charge today
Y su declaratoria por el delito de haber conducido en el día de hoy
may be used against you
podría ser usada en su contra
by the Department of Highway Safety Motor
por
Vehicles
el Departamento de Seguridad en las carreteras y vehículos de motor.
for a further revocation of your driving privilege.
Y ellos podrían revocarle su privilegio de conducir más adelante.
Do you understand that?
¿Entendió eso? Yes.
Mr. Valise, will you stipulate to venue and the factual basis contained in the discovery material in both cases?
Yes, Your Honor.
Mr. Cabrera, anything further from you?
No, Your Honor.
All right, sir, I will accept your plea and your admission.
Señor, acepto su declaratoria y su admisión.
I find that they are freely, voluntarily, knowingly entered
Encuentro encuentro que han sido hechas libre, voluntariamente y con conocimiento de causa,
upon a factual basis and in your best interest.
con motivo fundado y lo que más le conviene.
Adjudication in both cases.
Su culpabilidad va a constar en ambos casos
Judgment and sentence as I previously stated.
y fallo y sentencia según le indiqué anteriormente.
Thank you, sir, and good luck to you.
Gracias, señor, y buena suerte.
And thank you, Mr. Belize. Accept. Okay, and that was Mr. Lopez. Next up is Christopher. Thank you very much. Do you need a signature?
Yes.
Well, I thought I still have a Gerardo Lopez Ortiz, but they didn't announce him. I don't know that they have him. But let's see. Which ones am I doing? All of them?
No,
that's
sir.
not just these.
The last two.
Just the last two?
Yes, sir.
Okay, so thank you.
Thanks.
This is, you're Mr. Ott, right?
Yes, sir.
All right, thank you. We have 3 cases here with Mr. Ott. 20 MM 1449, that's a battery domestic violence. 20 MM 1892, that's battery domestic violence resisting without. And 20 MM 1884, the violation pretrial release, all cases with Ms. Hall.
Supervision with weekly breathalyzers, batterers intervention program, no possession or consumption of alcohol, substance use evaluation for all recommendations for testing, no contact with Deja Jeffers, DEJAH,
Oh, DEJAH, that's the first name.
Yes.
Jeffers, JEFFERS. Thank you.
In 20 MM 1792, the terms are for count 1 battery. Random testing and no contact with the same victim, Deja Jeffers. And for count 2, resisting without violence, adjudication, 90 days in jail with credit for time served, versus case concurrent with all cases and counts. And in 20 MM 1884, the adjudication of guilt, all costs to include $117.50 of 1750 to Collier County Sheriff's Office. 60 days in jail with credit for time served, for concurrent with all cases and counts.
Okay,
All that's correct, Your Honor.
thank you. And the alleged victim in all of the counts sounds like is the same person. And Mr. Cabrera, have you consulted with that person to see if she agrees with these offers?
Yes, Your Honor. In the notes, it shows that she has been consulted with the offers.
And she agrees?
Yes.
All right. And so based on, it sounds like you're reading notes, someone in your office, a prosecutor, based on their conversations with her and their review of the allegations in all 3 cases, believes that these offers are appropriate?
Yes, Your Honor. The ASA would be Mr. Stewart.
All right. And Madam Clerk, I'm going to go over all 3 of those again, okay? All right. Sir, tell me your name again, please.
Christopher Ott.
All right, Mr. Ott, there's a lot to that. Let's go over it again case by case to make sure we're all on the same page, okay? And we're going to start with 20 MM 1449. In that case, you're charged with battery domestic violence. And the offer in that case is as follows. It's an adjudication of guilt, all costs, and that includes court costs, costs of prosecution, and public defender costs. You would be placed on probation for 12 months with no possibility of early termination, and you must get all terms completed no later than the first 11 months of your probation. You would have 90 days in jail as a condition of your probation. You do get credit for all of the time you've already served. Additional conditions include Batter's Intervention Program, which you need to sign up for within 30 days of your release from custody. Substance abuse evaluation, follow all recommendations. For that evaluation, you also need to sign up for that within 30 days of your release from custody. No possession or consumption of alcohol. Random testing, I think I've said that. No contact with Deja Jeffers. In addition to that, the first 3 months of your probation will be intensive supervised probation with at least weekly breathalyzer tests. Ms. Hall, do you agree that's the offer in 20 MM 1449? First 3 months, intensive, yeah. Now, was it your intention, sorry? With weekly breathalyzer, and that's a minimum because it also includes random testing. So they may do it more than that, but at least weekly. Mr. Cabrera, is that your understanding of the offer in that case?
That is, Your Honor.
I have a question for both of you. Is it your intention that after the 3 months it automatically switches to standard probation? Absent a VOP, of course. If there's a VOP, then that may change. But if absent no VOP, Mr. Cabrera, is that your understanding?
I don't have an explicit note to that, but I would assume that, yeah, that would be how it functions, Your Honor.
All right, so after the first 3 months on intensive probation, it will automatically switch to standard probation unless there's a violation. If there's a problem, you're going to have to come back to see me. Okay, so Mr. Ott, do you understand the offer in that case?
I do understand.
Any questions about it?
Yes, sir.
And do you want to accept it?
Yes, sir.
All right, let's move on to the next. Are you good on that one, Matt? All right, let's move on to the next one. 20 MM 1792. That's 2 counts. One is battery, domestic violence. Count 2 is resisting without violence. And the offer on count 1, which is the battery, domestic violence, is an adjudication of guilt, court costs, cost of prosecution, public defender costs, 12 months of probation consecutive to the first case. So it doesn't even start to run until you finish the first 12 months. You do have the possibility of terminating your probation in this case after 3 months. If you're successful by then, it's not automatic, but it is a possibility. No possession or consumption of alcohol, random testing at your expense, and no contact with the same person. That's count 1, battery. Count 2, resisting without, is an adjudication of guilt, composite costs, and 90 days in jail, concurrent to the first case, so it runs at the same time, and you do get credit for all of the time you've already served. Ms. Hall, do you agree those are the terms in this case? Mr. Cabrera, do you agree?
Yes, Your Honor.
And Madam Clerk, did you get all that?
Yes, Your Honor.
All right, Mr. Ott, do you understand the offer in this case?
Yes, I understand.
Any questions?
No, sir, no question.
All right, do you want to accept this offer as well?
Yes, sir, I accept.
All right, thank you. Your third case is 20 MM 1884. And in this case, you're charged with violation of pretrial release conditions. And the offer is an adjudication of guilt, court costs, costs of prosecution, public defender costs, and cost of investigation to the sheriff's office in the amount of $117.50 and 60 days in jail. I didn't make a note of this, but was that concurrent?
It says at the end of my notes, concurrent with all counts, although it's after an apostrophe after the 60 days jail credit time served.
All right, so it sounds like it's concurrent. And Ms. Hall, is that your note as well? All right, so the 60 days in jail on this count is also concurrent with the first 2 cases. It runs at the same time, and you do get credit for all of the time that you've already served. You understand that?
You understand?
Any questions?
Yes, sir.
Do you want to accept the offer in that case as well?
Yes, sir.
All right, and are you entering a plea of no contest in all three cases?
That is correct.
Did you read and sign a plea form?
I did.
Do you understand everything that's explained on the plea form?
Yes, sir, I understand.
Do you understand that those rights apply to all three cases?
I do understand.
Do you understand that by entering your pleas today, you are waiving those rights in all three cases?
I do understand that as well.
Your pleas will be used against you in a deportation proceeding if you are not a United States citizen. Do you understand that?
Yes, sir.
Are you under the influence of drugs, alcohol, or medication?
Yes, sir.
All right, battery is an enhanceable crime. If you commit that crime again, then you may face higher fines, more jail time, and possibly a felony charge. You understand that?
I do understand.
All right, Mr. Cabrera, anything further from you by way of plea colloquy?
No, Your Honor.
Ms. Hall, how about you? All right, so we've got all three cases here. I need just a minute, Mr. Ott, to read the booking sheets. So give me just a minute to do that, please. All right, pretrial release conditions was based on contact from the jail. Now, Mr. Cabrera, we've got a no contact order in both of the battery counts, two cases. We didn't say anything about a no trespass order. What's the state's position on that? I do have an address here in the booking sheet. Was that an intentional omission?
I don't see anything about it being an intentional omission, but at the same time, I don't have an explicit note saying that they did not want a no trespass, and if they have the no contact order, I would have, I kind of assumed that they would want a no trespass as well. I'm not sure if that changes anything, or if maybe the public defender has more context.
Well, let me ask, Mr. Ott, do you still live on 8th Street North?
I do, but I didn't plan on living there.
I'm just trying to figure out this trespass because I've got an 8th Street North address. Is that the alleged victim's address?
Theirs is 701 Apartments address that's on the booking sheet for the no contact violation. I can't remember the address there.
Okay.
It's like Plantation Way.
That's her address? That's her current address?
Correct. Mine is the 8th Street address, but I have to see what's going on right now.
Okay, so yeah, because you know that wherever she's living, you can't go there.
Oh, I totally.
All right, so Mr. Cabrera, you're requesting a no trespass order in all three cases for her current address?
Yes, Your Honor.
Mr. Ott, that would be included. It's consistent with the no contact order. We would add a no trespass order at her current location, which I'm looking for. Give me just a minute. And Mr. Cabrera, I need you to look for this as well. Mr. Ott thinks that's, oh, I do see a plantation, 3560 Plantation Way. So no trespass, Madam Clerk. I'm sorry to add that to you. All three of them.
All three, yes, sir.
Your Honor.
Yep.
I did reach out to Mr. Stewart. He's saying it's not necessary, the no trespass order. But again, based on our conversation, I don't see why we wouldn't. But yeah.
Well, I think he may be saying that because it's encompassed in the no contact order. If she's there, he can't go there. But I would want to add that anyway, and Mr. Ott says he's okay with that. Okay, so let's add that. Madam Clerk, do you need the address again?
Yes, Your Honor, I do.
3560 Plantation Way in Naples. And on the one case with 2 counts, that'll be on count 1, battery. The other cases, there's only a single count. Okay, so with that, Ms. Hall, will you stipulate to venue and the factual basis contained in the discovery material in all 3 cases? All right, sir, I'll accept your pleas in all three cases. Find your pleas freely, voluntarily, knowingly entered upon a factual basis and in your best interest. Adjudication, all counts, all cases, judgment and sentence as I previously stated. Thank you, Mr. Ott. Good luck to you, sir.
Thank you.
Yes, sir.
Thank you, Markley.
The clerk did a bonehead thing, so she's gonna need to. I hit a button and I got her.
That's frustrating. You just want to take that button back. That's all right. No rush. We do have one other person here, Gerardo Lopez Ortiz. Yeah, we had two cases with Lopez, right? I think that's Mr. Belize. Oh, we had two cases with Nelson Lopez. Yep, I do. It's 20 CT 2277. This is a Gerardo. So this morning it was Gerardo Lopez. Afternoon it's Gerardo Lopez Ortiz. Maybe. Let me talk to the attorneys first, okay? Because this is Miss Hall's case. But before we get there, I still need to wrap up some paperwork before. No rush. I know we did 3 cases all at once, so that's a lot. So no problem.
No, it's
Yeah,
right
no, that's
here.
okay.
It's mine.
Stephen, would you be willing to talk to Miss Hall about that? And she'll tell you what she would like with her client, whether he's in custody or what. Sure. Okay.
Then you're gonna have to watch and do everything else.
Yeah, no problem. So this is 1449. Okay. Accept. And 20 mm 1449. Yeah. Well, that's all for that case, right? I mean, it looks like you've entered everything there.
I believe so. Now I'm just working on count 2 of the second.
The only thing that's not specifically in there is that it automatically converts to standard probation after the 3, unless I missed that. So. Yes. With all cases. Yes, ma'am.
I'll just put them in individually.
Mr. Cabrera, are you still with us?
Yes, Your Honor.
All right. We're just wrapping up some paperwork on Mr. Ott.
I understand, Your Honor.
And then I think we do have one case left. Sure. Okay. That's not a fix, it's just one slight addition. One small additional thing. Yes. Except count 2, resisting without. If we all stared at you, would that help?
Oh, tremendously.
Yeah. We're not in any rush.
You can watch me sweat and everything.
I'm enjoying the break, so take it up. Yeah, that helps. I do the same thing. You're on 1449. Yeah, we just need to note that it automatically changes after 3 months to standard reporting probation.
I can see just almost we're finishing up on previous case. Just confirming, this is Arno, Lopez, Luigi.
Probation after 3 months?
Thank you.
Yes, it is. Yep, except on 1449. So are you done with all 3 cases?
Yes, sir.
All right, so let's we'll see. 20 mm 1792. Let's look. Except count 2. Let me look at count 1. I do have one request there. Just to make sure it's clear, I know that on the 3rd line there you say consecutive to 1449. Can you put that down closer to probation? Just so we know that the 12 months of probation consecutive to.
Yes.
Or just parentheses consecutive probation.
I can do that. That was,
Have a good afternoon.
1449, yes.
1449. Okay, accept. Perfect. Yeah. And then the last case, 1884. That is all costs, 117.50. Cost of investigation, adjudication, 60 days. No trespass. Jail time concurrent. Accept. Made it. No problem. You're going to be happy to hear the next charge.
Just one.
And it's no valid DL.
Oh, that is.
Don't we love those?
That's fantastic.
Yeah.
Yes, sir. I'm thrilled.
Good afternoon, Mr. Lopez Ortiz. Will you please stand up, raise your right hand, take an oath?
Buenas tardes, señor López Ortiz. Póngase de pie y levante la mano derecha.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Jura o afirma que el testimonio que te vas a dar será la verdad, toda la verdad y nada más que la verdad. Yes.
All right, good afternoon, sir. Will you tell me your name?
Buenas tardes, señor. Dígame su nombre. Gerardo López Ortiz.
All right, sir, you're here today on the charge of driving without a valid driver's license.
Señor, usted está aquí hoy por el delito de haber conducido sin licencia válida.
Your attorney is in the courtroom with me.
Su abogado se encuentra en la sala conmigo.
Miss Hall, what would you like to do today? Thank you.
A nombre del señor López Ortiz, él va a estar retirando su previa declaración de no culpable. Va a hacer una declaratoria de no disputo. Se le ha ofrecido que su culpabilidad no va a constar y costas, incluyendo los honorarios del fiscal y de la defensora de oficio.
With 90 days to pay.
Y 90 días para pagar.
Mr. Cabrera, do you agree with the terms?
Yeah, those terms are correct, Your Honor. Withhold costs and cost prosecution.
And there is an immigration detainer in this case.
Señor López Ortiz, existe una detención de parte del Departamento de Inmigración en su contra.
All right, sir, the offer on your charge is a withhold of adjudication,
La oferta en su caso es que su culpabilidad no va a constar
court costs, cost of prosecution,
costas procesales, costos de fiscal,
public defender costs,
costos de abogado defensor,
with 90 days to pay.
90 días para pagar.
Do you understand that?
¿Entendió eso? I didn't understand about pleading guilty.
You did, what did he say? He didn't understand?
About pleading guilty.
Oh, well, you don't have to plead guilty if you don't want to.
Si no se quiere declarar culpable, que no tiene que hacerlo.
The first thing I want to do, hold on one second, sir.
Un momentito.
The first thing I want to do is make sure you understand the offer.
Lo primero que quiero hacer es asegurarme de que usted entiende la oferta que le han hecho.
And then I will explain your options to you.
Y después le voy a explicar sus opciones.
Do you understand that?
¿Entendió eso? Hable.
Okay.
Yes.
The offer is a withhold of adjudication,
La oferta es que su culpabilidad no va a constar.
which means you would not be convicted of the charge,
Eso quiere decir que no le va a quedar una condena por ese cargo,
but you would be required to pay all costs within 90 days.
pero va a tener que pagar todas las costas dentro de 90 días.
That's the offer to resolve the no valid driver's license charge.
Esa es la oferta si usted quiere resolver su cargo de haber conducido sin licencia válida.
If you understand that,
No.
no what? What does that mean, no?
¿Qué quiere decir no? I will not accept the offer.
Okay, that's fine. Do we have another court date? Let's check. All right, let's see, canceled. I don't see any other notices. Maybe we need to set this, Madam Clerk, for a PD pretrial.
It's set for a non-jury pretrial, January the 25th.
Oh, perfect.
9 a.m.
So we'll leave it as previously said. Okay, sir, nothing else to do today. Thank you.
No tenemos nada más que hacer hoy. Gracias.
All right, and I believe that completes our docket. Anything further to come before the court?
No, Your Honor, not from the state.
All right, thank you, IJC. Thank you, everyone here in the courtroom. We are adjourned. Have a great day. Thank you.
You too, Your Honor. Thank you.
Thanks so much.
Oh, sure.